Good morning.
Good morning, Your Honor.
Hold on a second. I think everyone's getting connected.
Okay, you're on mute. Thank you. Thanks, Ross.
Okay, I think we got everybody. Good morning. We're here on the case of Selmer versus Jones, 13 DR 55. Please introduce your appearance, Ms. Yuri.
Yes, Your Honor. Attorney Nikki Yuri representing the co-guardians of the minor child, Lori and Patrick Cleary.
Okay, and I see the guardians are there and present. Mr. Selmer, good morning.
Good morning, Your Honor.
Are you self-represented still here today?
I am, Your Honor.
Okay, excellent. Ms. Yuri, we're here on your motion to domesticate, correct?
Yes, Your Honor.
Okay, please proceed.
Okay. Yes, at all relevant times, all parties to the case have been Florida residents. However, on May 23rd, 2014, the biological parents took the child on vacation to Indiana, where the mother, in a drunken state, dropped a pot of boiling hot water onto the child, severely burning the child with third-degree burns over 70% of his body. At the time of the incident, the parents called the grandparents, who are the co-guardians of the child, and told them about the incident. And the grandmother was a nurse, and they were doing FaceTime, so she was able to see, the condition of the child and realize the child was going into shock with life-threatening injuries. So she demanded the mother call 911 and get an ambulance for the child. The father didn't want there to be an ambulance for the child, and he didn't want to call 911 because they were drunk and had drugs on the premises, and he didn't want the police to be involved. But the mother called 911, and the child was in the hospital for 5 days, forced to go severe, extremely painful medical procedures that involved scraping the skin off his severely burned back. At that point, DCF in Indiana took custody of the child, and on June 2nd, 2015, the Clearys, who are the maternal grandparents of the child, were awarded guardianship over the child. Since that time, and for the great majority of the child's life, he's always lived in Florida. Indiana simply had emergency jurisdiction over the child. And for that reason, we're requesting that this court domesticate the order, which was attached as Exhibit A to this petition, into Florida. And we also request that Exhibit B, which was the petition filed by DCF in Indiana, be admitted into evidence as Exhibit B, as well as the pictures of the burns on his back as Exhibit C. We also request that this court enforce the guardianship order, which awards the grandparents sole custody of the child, and prevent the parents from removing the child from this jurisdiction, as they've proven that they pose a serious danger to the child's health, well-being, and safety.
Okay. Ms. Yuri, just a couple quick questions. Is everybody in this case in Florida? I mean, is the father?
Everybody's here.
Oh, okay. So the only reason that Indiana took jurisdiction is because they went on vacation and it was an emergency jurisdiction, right?
Correct.
Okay. All right. Where's the mother?
She's in Bonita Springs.
Okay, she's local too. All right.
Yeah, everybody's here, so it doesn't make sense for Indiana to maintain jurisdiction.
Okay. All right. Thank you, Ms. Yuri. Mr. Selmer, what's your position with respect to the relief that's being requested today, which is simply the domestication, admitting the exhibits that occurred in that case?
You'd like me to start where, Your Honor, with that? Can I let you know what happened in Indiana first, very briefly?
Absolutely, and I'll let you know that normally I like keeping the hearing to what the point is of the hearing, but this is
Yes,
the first
sir.
time you're all in front of me, and I do want to understand what occurred. So yes,
Okay, Your Honor,
I'm not going to put you under oth for this. I'm going to treat this as if opening statement because I don't think this is an evidentiary hearing. Okay.
It states it's an evidentiary hearing, Your Honor, but I hope that didn't hurt my case here, but that's what it says on the paperwork.
Why don't you just tell me what your position is and what happened?
Yes, sir. I had gotten shared custody with the mother after a lengthy court battle. I was an Indiana resident. The mother had lived down here to be with the grandparents. So the battle was in Naples, Florida in 2013 in front of Judge Creer, Your Honor. We got our final judgment. When Dominic had come back to Indiana and had gotten injured by his mother, who was listed as the perpetrator in the case, I was listed as not involved, was how that went down, Your Honor, with the CPS investigation.
Hold on.
I've got the only thing it says about me, Your Honor.
Give me 1 second. To the Guardians, he didn't interrupt. Yeah. This isn't evidentiary. I just want to hear what's going on. This is the first time in front of me, so let's set the standard. No interrupting while anybody else is talking. Only you are represented by counsel. Let your counsel do the talking for you. Would you like me to put you all on mute so there's no issue? Okay. All right. Please proceed, Mr. Selmer.
Thank you, Your Honor. Mrs. Cleary was removed from Judge Creer's courtroom for her outburst in 2003. Also, I'd like to point out, sir, by the bailiffs because of her outburst.
Okay, let's focus.
Okay, sir. So when Dominic came to Indiana and he was injured, he came for a month visitation for me that was court ordered in our final judgment. His mother asked if she'd come along. She had told me she was sober at the time. She showed up in Indiana for my month with my son to my lake house. It was a disaster, Your Honor. I signed over the guardianship so the I voluntarily signed over the guardianship so the grandparents could bring Dominic back to Florida where he had been living and he was comfortable there. His grandma's a nurse. I had no problem with that. 6 years later, the issue arises after I had separated from his mother. They have cut off all contact from me and are now just playing smoke and mirrors with who's got who and who's in charge of what, Your Honor. I haven't seen my son for a year and a half, Your Honor. They have blocked my telephone calls. No one will respond to birthday presents. They send back Christmas cards that I mail my son. They've threatened to call the law on me if I stop by to visit my son, Your Honor.
Okay. So let me ask you this. You're currently in Florida, right?
Yes, sir. I own a sober living home in Fort Myers. And I also work at a golf course down by the beach. I am a resident of Florida. Yes, sir.
Okay. Are you objecting to this court assuming jurisdiction in the order being domesticated here?
No, Your Honor. I had actually put in my paperwork that I would like things to be consolidated here because it's true. All the involved parties are in Florida. But when they threw up the guardianship as a defense for why they're not letting me see my kid when I went after their daughter for contempt of court for not allowing me to see my kid, they jumped in with their attorneys and waved that guardianship document around in Indiana, Your Honor. I'm doing this all myself. I decided to attack the validity of the original guardianship in Indiana on my own and did a lot of research in Indiana. And when it got to that point, I did hire counsel with my stimulus money. The last money I had, the only money I could spend, I spent on an attorney in Indiana because I thought the fight was going to go there. So the day before we were supposed to have court last week, they got a continuance. They're just playing the court systems and keeping my son from me, Your Honor. I have no problem with it being brought here. I just want, Indiana is about to rule on the visitation part alone, and then I have no problem. I just want this resolved, sir.
Okay. All right. Well, Miss Yuri, based on what's being said here, I don't think there is any issue whatsoever with the court with your petition to domesticate the guardianship order and this court basically assuming jurisdiction over it, even though I don't think the court ever lost jurisdiction over it based on the history of the file. So the guardianship order will be granted, as will your request to take as exhibits the exhibits, I think it was A, B, and C to it.
Yes, Your Honor.
As it relates to, there's nothing else that's before the court here today, Mr. Selmer. So I understand that.
Visitation,
Yeah, that's nothing that the
visitation,
court,
Your Honor.
nothing that the court's going to be able to determine today. The only thing before the court today was whether or not we're going to be domesticating that order, which we are. So I expect us to be back here again at some point, hopefully very soon, where we can discuss the issue of visitation.
Can we set a date for that, Your Honor? Well, so should I keep pursuing my modification of the guardianship in Indiana, which we should have resolved this week? Or
I can't
next
speak
week?
for the, I can't speak for the Indiana court, but based on the fact that we're domesticating its order down here, I expect that the Indiana court's not going to have any other thing to do with the case. Basically, what's happening is that whatever occurred in Indiana, we're, in layman's terms, we're taking that order and just treating it as if it was an order of this court down here.
I understand.
So that means that everything can come here. It can all be consolidated here, and we can address issues going forward here rather than in Indiana. Again, can't speak for the Indiana court, but most likely when they see that their order's been domesticated, it will end all the things up here. I'll end all the things going on in Indiana. Mr. Selmer, I will advise you that this is probably a good time for you to seek counsel, local counsel here, in order to, obviously you're going to be seeking visitation. There's no motion before me right now for that I can see in the file. I can't rule on anything with it, but obviously we'll be back, and we'll probably be back very soon on that.
Judge, can we set a court date for that? Can we set a court date in the near future so I can get it? I can file Monday morning.
I don't have access
this is
right
dragging
now
out, and
to
I'm
be
missing
able
all
to set
kinds-
you. I understand your frustration. I don't have a calendar. I don't have my JA right now, but I can promise you that we're going to try and get this done really quickly. So once you file a motion, make sure you contact Miss Yuri so we can lay down some times on this very quickly. And we'll get to it as soon as we can. Miss Yuri, do you have any questions relating to the order?
Would you like me to prepare it for Your Honor?
Yes, please.
Okay, and would you like that email to your JA?
Correct. Yeah.
Okay, thank you, Your Honor.
Okay. Best wishes to everyone going forward, and especially Dominic.
Thank you, Your Honor, for your time.
Thank you. Bye, everyone.